Hello guys, welcome to my channel. Today I am dictating you legal dictation 500 words at the rate 100 word per minute. So let's get started. 3, 2, 1 and go. The appeal after granting special leave to appeal is filed by the appellant against the judgment of the High Court of Punjab and Haryana, affirming the judgment of the trial court convicting the appellant under section 340B IPC, but reducing the sentence from 8 years rigorous imprisonment to a period of 7 years under the aforesaid section. The appellant, who was tried along with his parents and two brothers, was acquitted of the charge under section 406 of the Indian Penal Code by the trial court. In view of his conviction under section 2304B IPC, the trial court did not find it necessary to record a separate conviction under section 498A IPC. We heard Dr. J.P. Dhanda, learned counsel for the appellant, and Miss Jaspreet Gogia, learned counsel for the respondent state. There is no dispute that the marriage between the appellant and his deceased wife took place on 24 January 1998. It was also not in the reason of controversy that she died well within 7 years of her marriage. It is undisputed that the death of the appellant's wife was unnatural and she died along with her child by way of drowning in a river. In fact, PW8 ASI in his deposition stated that both the dead bodies were secured together with one chunni. The only question is whether the death is to be attributed to cruelty/harassment on the part of the appellant arising out of demand for dowry as contemplated under section 304B of the IPC. Learned counsel for the appellant pointed out that the court did not consider the evidence given by the appellant and that neither cruelty nor any demand for dowry is made out. It is contended that the appellant's wife apparently took her life along with that of her daughter on account of the fact that she was consistently taunted by PW3, the sister of the appellant's wife, who was married to an industrialist. The appellant was earning a sum of rupees 3,000 per month. However, notwithstanding the same, the appellant had taken care of her by fulfilling the desire of the deceased wife to pursue education, and she was in fact doing her post-graduation at the time of her untimely death. The appellant's father, we note that the appellant along with his two brothers and mother were tried by the trial court, and trial court convicted the appellant and his mother under section 304B, but appellant's mother stood acquitted by the High Court had in fact financed the education of the deceased wife. Learned counsel for the state pointed out that no reliance is to be placed on the evidence of the DW6 and DW8. They were neighbors. Their evidence supporting the case of the appellant should be perceived as born out of their need to maintain cordial relationship with their four neighbors. As to what happened within the four walls of the house, she would question as to how could they depose before the court. Stop. Thanks for watching. Please do like, share and subscribe the channel for more dictations, and don't forget to press the bell icon for future notifications.